This courtroom morning begins quietly, but beneath the calm, big decisions await. Terrence Smith stands before the judge, ready to plead guilty to a controlled substance charge. It sounds routine, but every yes, sir, hides a story of addiction, pressure, and consequence. Stay tuned. This plea might seem simple, yet the ripples will shape his future.
Defendant will be pleading guilty to the charge of use of a controlled substance, a 1-year offense. Upon his successful plea to that charge, well, the counts are wrong then. He's actually pleading to count 3, not 2, of use of a controlled substance, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would then be dismissed. That's the court's full understanding of the agreement.
Is
that correct?
Attorney, that's correct, Your Honor.
Your Honor.
All right. May I have him sworn?
The testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be done.
Yes, sir.
State your name.
Terry Smith.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding that, you still wish to plead guilty?
Yes, sir.
I do have to advise you that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in 14A2 District Court. You understand that?
Yes, sir.
Sir, to the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or went over that with counsel?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You'll see on the podium, please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
I don't know where my complaint is, but let's find it. On the date of September 8, 2022, at the location of 505 South Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was fentanyl?
Yes, sir.
All right. Sir, if I do accept your plea, I have to advise you that it's between the time of my acceptance of your plea and the time of sentencing. If you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or inducements which have led to this plea?
None that I'm aware of, Your Honor.
Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 3, and I have amended or corrected the form to accept his plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in the...
When Smith's lawyer asks for bond reinstatement, you can almost feel the tension shift. One request, one hope for freedom, denied. The judge's refusal keeps him in custody. Was it fairness or caution? Viewers, what would you decide if you were in that seat? Justice often balances mercy and accountability, and today, it leaned toward control.
I met with him yesterday. I think he has the understanding, and he gave some explanation last week of what happened. He's asking that the court reinstate his bond as a PR bond, allow him to go back to community corrections and test. And obviously, he's going to have to continue to test negative all the way up until sentencing. That may have a bearing if he's going to test positive with Judge Barr between now and sentencing. So I'd be asking for a PR bond.
I'm going to deny your request. I will indicate I'm going to leave that to Judge Barr after probation sees him within the next few days, and certainly they can make a recommendation to Judge Barr regarding his release. in this matter, but I'm going to deny that request. His bond will continue at this time. All right.
You're right.
Thank you. Court does call the case of People versus Kristen Anthony.
It's Stephanie Cannon on behalf of Miss Anthony. But not with, Your Honor.
Really?
I
went almost the whole morning without a bench warrant.
and you could continue. It would. We could just adjourn this. It would. I'm asking. Maybe. No. And how, good morning to you in court, Your Honor. Yeah, I saw that.
Yeah, you did.
I did.
Okay, go ahead.
Just asking for the adjournment.
Yeah, okay.
Yeah. What are you?
Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
25,000, thank you.
Yes, ma'am.
Thank you, Your Honor.
Court does call the case People versus Robert Barner.
Count Overwater, Assistant Prosecuting Attorney for the People.
Morning, Rob J. Coe on behalf of Mr. Barner. Robert, would you state your name for record?
Robert Barner.
Judge, today's time date for a PCC in this matter. We're asking to set this for a preliminary exam.
Discovery is complete.
99% of it, Your Honor.
There's one report, Your Honor, that's outstanding. I have requested that from the OIC.
One report.
There's a police
Just a-
report that describes the initial stop.
Okay. Well, I'm going to indicate that discovery is complete except for the initial stop report.
That's correct, Your Honor.
If you don't have that, that's not going to be a basis for adjournment.
We'll have it, Judge.
All right. And, oh gosh, it's Kilowald. This is going to be really
Judge.
complicated. I have 2 days, Mr. Kilowald, that I'm going to set it. I can set this. I can set this for the 10th if the people would have their witnesses available, or I'd set it for the 13th. On that date, I have two times. Because
The courtroom barely pauses. New defendants step forward. Different names, same stakes. Each story unfolds like a chain reaction of missed dates, legal misunderstandings, and second chances. What does it say about the system when every voice echoes the same words? Adjournment requested? Sometimes justice feels less like a verdict and more like waiting for one.
Why not?
all right. Preliminary examination in person, November 13th, 2025 at 9 a.m. or at 10 a.m. That's
you,
before
Judge?
Judge Barr.
Judge Barner. Thanks, Judge.
Bond continue.
Appreciate your consideration.
Thank you, sir. Court does call the case of the People versus Santana Arlington.
Morning, Your Honor. Assistant Public Defender Chelsea Vergils with and on behalf of Santana Arlington, who appears via Zoom. Ms. Arlington, please unmute and state your name.
Hi, Santana Arlington.
Thank you.
Your Honor, we're just asking to adjourn briefly for a plea discussion.
Probable cause conference, November 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, ma'am. Court does call the cases of the People versus John Devine.
People.
All three cases.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Devine, who is approaching. State your name for the record, sir.
John Patrick Devine.
Thank you.
Thank you, Your Honor. As to all three cases, I'm requesting an adjournment. We did receive the discovery in the most recent case yesterday, but I still need to review it and then review it with Mr. Devine.
Okay.
And I'm also asking, to address bond when appropriate.
I will adjourn probable cause conferences to November 13, 2025, 9 a.m. As to bound.
Thank you, Your Honor. I'll start out with the bad fact, so to speak. So Mr. Devine does have three cases before Your Honor. One of them is a 2022 case that he was bench warrant status for failing to appear for a probable cause conference back in May of 2023. I asked my client, frankly, why he missed court that day, and he advises that he does have a traumatic brain injury, and frankly, he forgot about court. I asked him moving forward if he was released, how he would get back to court, and he advised me that he had a case manager through Michigan Ability Partners. I was personally able to speak directly to his case manager. Her name's Wonder, who advises that she does work with Mr. Devine. And then she also mentioned that she said no problems with him and he's a nice guy, which of course didn't surprise me. But she also advises me that not only can she work with him to remind him of his court dates, she can also arrange rides for him to get here to court. She also advises that through this MAP, Ability Partners, he does receive a housing voucher that covers his full housing and utilities. He does stay at an apartment, I won't say out loud, in Ypsilanti, that the court should have the address. He resides there by himself. His case manager, Wonder, also stated to me that she has been discussing and working with him about getting an application in for him to get SSI. So that being said, I do believe he has a good support system in place to get him back to court. Two of the cases are possession related, and he does understand that if released, he would likely be ordered to drug test and has no issue with that. I did speak to his case manager as well, that I would advise her what court, any bond conditions, so that she can help get him on the path. I'm
How do you
asking,
come into custody?
I believe one of the newer cases, Your Honor.
So
When attorney Natalie pleads for John Devine, a man with a brain injury who forgot his court date, you can sense the human side of justice. It's not just about laws. It's about lives that bend under pressure. His story blurs guilt with struggle. Should courts weigh compassion as heavily as compliance? Let me know your thoughts below.
So effectively $100. We're asking if he'd be released on his own recognizance.
I don't need a response, given that he was picked up on new charges. I get the circumstance that he's in, but he's picked up on new charges that brought him on the old charge. The court's going to decline at this time to reduce his bond. So his bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Anitha Barnes.
John Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defendant, Magistrate Archuleta, Your Honor, on behalf of Ms. Anita Barnes, she should be on Zoom, Judge.
Mr. Barnes?
Barnes, could you state your name?
Yes, I
Anitha
think she
Barnes.
is. State your name, please.
Anitha Barnes.
Thank you.
Judge, we'd like to set this matter for preliminary exam, please.
Really?
Yes,
Okay. Discovery complete?
to our knowledge, Your Honor.
Okay. Would everybody be ready on the 10th?
I'm aware of no reason why we couldn't.
10th should be fine with us, Judge.
I would ask.
You were.
But no. Preliminary examination will be set November 10th. That's a Monday. That's a Monday, 2025. That's 9 a.m. before Judge Valvo. All right. Bond will continue.
Thank you,
All right.
Judge.
Thank you, Your Honor.
Thank you, Ms. Barnes. Court calls case, People versus Stephen Kimura.
Stephanie Cannon on behalf of Mr. Samora, who is approaching.
Your name, sir?
Stephen Kumar.
Thank you, Your Honor. I did email this morning to the prosecutor's office our request for inpatient treatment. In his felony matter before Judge Mood on Monday, she agreed to release him to long-term inpatient treatment. And I am asking if the court would be inclined.
Would match that. Yeah, I'm
As
not gonna
well.
have a problem signing that if he wants to.
Okay. Your Honor, outside of that, we did receive discovery. I want to show it to my client. We got the video evidence that we needed. I do need to show that to my client, so I am going to ask for.
When you guys are preparing these orders, and I told you
What do you need?
that I certainly don't do that, he would be released, but it would be on a tether.
Your Honor, however he gets released to inpatient treatment,
Okay,
he
but
will be released to
you can
inpatient.
prepare a new order just indicating that language in it.
Yes, I can redo it, Your Honor, and get it to the court.
All right, so what do we want to do on this case?
Your Honor, we're just going to ask for an adjournment. I do want to go over that evidence with him so he can decide whether or not he wants to waive or set it for preliminary exam.
Grant the adjournment, probable cause conference, November 13, 2025, 9 a.m.
Thank you so much, Your Honor.
Bond continued. Thank you. Court calls case People versus Nathan Burgess.
By now, the pattern is clear. Bonds denied, exams delayed, and the judge holding a steady line of discipline. Each case, Barnes, Camera, Burgess, shows how tight the system's rhythm runs. But behind every name is a world of personal failure, recovery, or denial. Which do you think dominates this courtroom today, law or humanity?
My client and Mr. Overwater, we are in discussions on an offer on this file and a potential resolution. I'd ask for a 2-week adjournment and hopefully we'll get it wrapped up, Judge.
Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you.
Thank you, Your Honor.
Court calls case People versus Marcus Napier.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Napier, who is approaching. Please state your name for the record, sir.
Marcus Napier.
Thank you, Your Honor. I have discussed this matter with my client, and I believe discovery is complete with the exception of the 911 call that is on the way, and I did discuss this with the people. I would be asking to set this matter for preliminary exam, understanding that if for some reason we don't have the 911 call by then, it wouldn't be the basis for an adjournment. Excuse me. Sorry, sir.
And I found that, Your Honor, they usually come pretty quick.
Do either witnesses available on the 10th?
We'll try.
Preliminary examination in person will be set November 10th, 2025, 9 a.m. That is before Judge Falvo.
Thank you, Your Honor.
Thank you, Your Honor. Sorry.
Bond continued. Thank you.
Thank you, Your Honor.
Court calls case People versus Rodney Carter.
The public defender, appearing on behalf of Mr. Carter.
Mr. Carter on Zoom. Take that as a no.
Negatory Ghost Rider.
Okay, Judge, we'd ask for an adjournment for the record.
What?
I'd ask for an adjournment for the record.
Oh, Miss Apple's so nice. I almost don't want to do it, you know?
Tried.
But I've got to be fair to everybody. And just as mean. Sometimes that's fairness. Benchmark will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case People versus Ronald Sims.
I should call this with people.
Assistant Public Defender Chelsea Vergils with and on behalf of Ronald. Mr. Sims, please state your name.
Ronald Sims. Thank you. You're requesting an adjournment.
Yes, if possible, could we get the 13th, Your Honor? He has a court date in circuit court on the 18th, hoping to move this along before then.
So at what point do Vergils think she could ask for what date? Huh? Right now? Oh.
It was
Did
a mere
somebody tell her
suggestion.
that? I think Cannon told her to do that.
I'd be a trainer.
And I'm glad she has shed most of what you probably taught her. Of course, I can give you the 13th. We'll adjourn it. Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Much appreciated. Thank you.
Thank you. See, that's it. She's so nice. So I know she wasn't taught that by Candy. Just saying.
Listen closely as the judge spars playfully with an attorney about hearing loss. It's a brief moment of levity amid heavy cases. Then the next defendant enters, and tone snaps back to serious. That's the rhythm of real courtrooms. Humor 1 second, heartbreak the next. How do these judges carry that emotional weight day after day?
I thought you didn't hear it. I thought it was just low. We are going to.
No, I heard what you say. You're old and you can't hear.
Well, you usually
Is that what you were saying?
No, that is not what I was saying.
Yes, it is what you're. I'm hurt.
I'm sorry.
Okay, go ahead.
We're going to be setting this matter for preliminary examination, Your Honor. To our knowledge, all discovery is complete.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available on the 13th.
I expect we will.
Preliminary examination will be set November 13th, 2025, 2 p.m. That will be before me. And we'll continue this case. All right. Who's here with her? How old are you, young lady?
You said how old I am?
Yeah.
20.
20. Who's here with you?
My father.
Okay, I thought so. You were all up under him. My daughter would be with her dad when she's scared. Okay, thank you. Court calls the case, People versus Donovan Smith.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Smith. Mr. Smith, state your name for the record, please.
Donovan Smith.
Your Honor, I have two requests. I know.
I'm only giving you one.
The first is easy.
Okay, I'll take that one.
We're asking for an adjournment of the PCC. I believe we received the media discovery this morning. Additionally, there's forensics from the state lab that we're waiting on. Who knows how long that's going to take.
Right.
The second is bond. Mr. Smith would like me to address bond, if I may.
Yes. Is he held on anything else, or is this?
This is it.
Okay, go ahead.
So Mr. Smith has I believe his bond is currently set at $50,000. He is asking for a reduction, either a personal bond or at least a 10%. He would go home to his mother's home in Detroit. He has no reason for being in Washington County, so he's happy to stay out of the county. He's happy to wear a tether if the court would like to order one. He is not working right now, but he is a caregiver for his grandmother who was ill. She recently had heart surgery, so he does things around the house for her, helps care for her many medical issues. He is planning on going to school in December as well. So given all of that, we are asking the court to consider a personal bond or a reduction.
Response.
Your Honor, the people would object. Mr. Smith currently, according to Lean, has a felony carrying concealed weapon charge that was bound over in 3rd Circuit Court. He also has a felony unlawful driving away that was bound over in 6th Circuit Court. And then here in Washtenaw County, he is alleged to have fired a gun at a building. There are numerous shell casings that were recovered from the scene. He ran from the scene. He had to be chased down. There was I believe that a canine unit was called and had to find him. And we are waiting for DNA on these shell casings to strengthen this case. So the people would object to a bond reduction and believe it was set appropriately.
So he was on bond or some other type of court proceeding regarding a weapons charge, and then this comes up where it involves the firing of a weapon.
I can't confirm that he was on bond, Your Honor. My record only indicates that that matter was bound over in October of 2024. I don't have a resolution of it in 3rd Circuit.
Got it.
I don't know if this helps, but he's on HIDA for in Wayne County for the weapons charge.
So he's up, but he's, okay.
He's
So he's under sentence on a weapons charge and then picks up a case that involves discharge of a weapon at a building. Anything else?
he says he's been compliant with his probation there.
Except maybe the picking up of another charge,
And
particularly a weapons charge.
we do dispute these allegations.
I understand you do.
And he is set for sentencing in Oakland County on that other case on the 6th.
So he's under sentence, or he's about to be sentenced on something else,
Maybe he's HIDA there too.
and this offense happened.
Drop down to misdemeanor because it was attempted.
He says it's going to be a HIDA misdemeanor resolution there.
Okay. So actually, Ms. Perroni, you were wrong about something. Both of your requests are very easy. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
As the last case closes, Donovan Smith's plea denied, the courtroom settles. The law spoke firmly, consequences over excuses. But was justice truly served, or simply executed by procedure? If this lineup made you think about fairness, accountability, and the real lives behind legal files, hit like, share your opinion in the comments, and subscribe for more real courtroom breakdowns.